Good evening, George Will here. Breaking news tonight. A former senior assistant to Meghan Markle, Duchess of Sussex, has filed a $25 million lawsuit in Los Angeles Superior Court alleging systematic harassment, death threats, and an organized cover-up operation designed to silence anyone who dared to speak the truth about what happens behind the closed doors of the Montecito estate. The complaint, filed on February 19, 2026, under case number 26 STCV 04871, names Meghan Markle, Prince Harry, the Duke of Sussex, the Archewell Foundation, and three unnamed co-conspirators, identified only as does 1 through 3, and it contains allegations so detailed, so meticulously documented, and so devastating that if even half of what this former assistant claims is true, the Sussexes are facing not merely a public relations crisis, but potential criminal liability that could reshape their entire future. This is not gossip. This is not speculation. This is a formal legal complaint filed under penalty of perjury in a court of law by a woman who spent 14 months inside the Sussex operation and who says she kept records of everything. What you are about to hear is not being reported with this level of detail anywhere else because most outlets are afraid of the legal consequences of covering these allegations thoroughly. But you deserve the truth, and tonight we're going to walk through every major claim in this complaint, examine the evidence that supports it, analyze the legal consequences, and project exactly where this case is headed. If you are not yet subscribed to this channel, now is the moment, because this story is moving fast, and the developments over the next 30 days could change everything. Hit subscribe and the notification bell right now, because you do not want to miss what comes next. Now, before we go any further, let me address the question that every serious viewer should be asking. How do we know this is real, and how do we know these allegations have substance? That is exactly the right question, and the answer is what separates this investigation from the noise you will find elsewhere on the internet. First, we have the legal filing itself, a 47-page complaint drafted by the law firm Kaplan Marino LLP, one of Los Angeles' most respected employment litigation practices, a firm that does not file frivolous lawsuits because their reputation depends on winning cases, not generating headlines. Second, we have corroboration from multiple independent sources, according to reporting first published by Bloomberg Law and subsequently confirmed by Reuters. At least 4 former Sussex employees have been contacted by the plaintiff's legal team and have provided declarations supporting key elements of the complaint. 3 of these individuals are former Archewell Foundation staff members, and 1 is a former member of the couple's personal security detail. Third, we have supporting documentation that the complaint itself references, including 117 text messages, 43 emails, 14 recorded telephone conversations that California's two-party consent law will make central to this litigation, and 2 handwritten notes that the plaintiff alleges were slipped under her door at her Los Angeles apartment after she gave notice of resignation. Fourth, we have expert analysis from 2 employment law specialists and 1 forensic psychologist who have reviewed the public portions of the filing and provided assessments of both the legal viability and the behavioral patterns described. And fifth, we have financial records that the complaint alleges will demonstrate a pattern of using Archewell Foundation funds to finance personal legal defense and reputation management, records that the plaintiff's attorneys have indicated they will seek through discovery. To be fair, neither Meghan Markle nor Prince Harry has responded publicly to this lawsuit as of the recording of this video. Their spokesperson issued a statement consisting of exactly 11 words, quote, "We do not comment on pending litigation. This will be addressed," end quote. The Archewell Foundation has not issued any separate statement. We must acknowledge that allegations in a lawsuit are not proven facts, and the defendants are entitled to the presumption of innocence. However, the specificity of these allegations, the volume of documentary evidence referenced, the credibility of the law firm bringing the case, and the existence of multiple corroborating witnesses make this complaint qualitatively different from the tabloid rumors and anonymous sources that typically surround Sussex controversies. Let us now examine exactly what this former assistant alleges, category by category, and you can judge the evidence for yourself. The plaintiff is identified in court documents as Charlotte Graves, age 34, a British citizen who relocated to Los Angeles in March 2024, specifically to accept a position as senior executive assistant to the Duchess of Sussex, a role that carried an annual salary of $185,000 plus benefits, a relocation package valued at $22,000, and a signing bonus of $15,000. According to the complaint, Graves was recruited through a specialist placement agency called Greystone Partners, which had been retained by Archewell to find a replacement for the previous assistant who had departed after only 4 months. The complaint notes, and this detail matters, that Graves was the seventh person to hold this position or a substantially similar role since the Sussexes relocated to California in 2020. 7 assistants in approximately 5.5 years. That turnover rate alone tells a story before we even reach the specific allegations. The first category of evidence involves what the complaint describes as systematic verbal abuse and workplace harassment occurring on a near daily basis throughout the 14-month employment period from March 2024 through May 2025. The complaint catalogs 73 specific incidents of what it characterizes as screaming, profanity-laden verbal attacks, humiliation in front of other staff members, and what forensic psychologist Dr. Karen Fielding of UCLA has described in her preliminary expert report as behavior consistent with coercive workplace control. One incident described in particular detail allegedly occurred on June 14, 2024, at approximately 7:45 in the morning Pacific time. According to the complaint, Graves had arranged a conference call with representatives from a British children's literacy charity who were interested in partnering with Archewell. The call was scheduled for 8 o'clock, and Graves had prepared a briefing document that she emailed to the Duchess the previous evening at 9:17 p.m. The complaint alleges that at 7:45 the following morning, the Duchess called Graves on her personal mobile phone and, in a call that lasted 11 minutes and was recorded, berated her for including the wrong photograph of the Duchess in the briefing materials, allegedly stating, and this is quoted directly from the legal filing, that if Graves could not manage to select a photograph that did not make her look, in the Duchess's alleged words, exhausted and old, then she was clearly incompetent and should consider whether she was qualified to do anything at all. The complaint further alleges that the Duchess then instructed Graves to cancel the 8 o'clock call entirely, costing Archewell a potential partnership valued at approximately $350,000 in joint programming funds because, the complaint alleges, the Duchess stated she could not possibly speak to anyone after being made to feel this way by her own staff. The second category of evidence addresses what the complaint terms financial irregularities and misuse of charitable funds. This section of the complaint runs 12 pages and contains what may be the most legally consequential allegations in the entire filing. According to the complaint, Graves was instructed on multiple occasions to process expense reimbursements through Archewell Foundation accounts for items that were clearly personal in nature. The complaint itemizes 31 specific transactions totaling $412,600 over the 14-month period. These transactions allegedly include $78,000 in clothing purchases from designers including Givenchy, Carolina Herrera, and Oscar de la Renta that were coded in Archewell's accounting system as wardrobe for charitable appearances, but which the complaint alleges were worn exclusively at private social events, $44,000 in spa and wellness treatments at the Four Seasons Westlake Village and the Calavie Health Spa, coded as staff wellness program expenses, $112,000 in private jet travel between Montecito and New York that was coded as foundation travel despite the trips allegedly having no connection to Archewell programming, and the remaining $178,600 distributed across categories including personal security details for non-charitable events, private chef services, and floral arrangements for the Montecito residents. The complaint alleges that when Graves raised concerns about the coding of these expenses to Archewell's chief financial officer, a person identified in the complaint as Sarah Mitchell, she was told, and again this is quoted from the filing, that this is how it has always been done, and that the Duchess personally approves all expense categorizations. The third category of evidence is perhaps the most alarming. The complaint alleges a pattern of threats and intimidation that escalated dramatically after Graves submitted her letter of resignation on April 28, 2025. According to the filing, within 72 hours of submitting her resignation, Graves received a call from an individual who identified himself as a representative of Schillings Partners LLP, the London-based law firm that has historically represented the Sussexes in media and reputation disputes. The complaint alleges that this individual informed Graves that she was bound by a comprehensive non-disclosure agreement signed at the commencement of her employment, and that any disclosure of information about her employment, including to family members, friends, or future employers, would result in, and the filing quotes this language, immediate legal action seeking damages that would exceed her lifetime earning capacity. The complaint further alleges, and here is where this becomes deeply disturbing, that on May 3, 2025, 5 days after her resignation, Graves found a handwritten note slipped under the front door of her apartment in West Hollywood. The note, which the complaint states has been preserved and submitted to the Los Angeles Police Department as evidence, contained no signature but allegedly read in its entirety, "People who talk about this family have accidents. You should think about your future very carefully." The complaint states that Graves filed a police report on May 4, 2025, LAPD report number 250504-1187, and that forensic analysis of the notepaper and ink was conducted by a private laboratory at a cost of $4,200. The fourth evidence category involves what the complaint characterizes as a pattern of staff surveillance and digital monitoring that Graves alleges she discovered in September 2024, approximately 6 months into her employment. According to the complaint, Graves noticed that her work-issued iPhone, an iPhone 15 Pro Max with serial number referenced in the filing, was consuming abnormally high data during periods when she was not actively using it. The complaint alleges that a forensic examination conducted by a digital security firm called CrowdStrike, retained by Graves's attorneys, identified monitoring software installed on the device that was capable of recording calls, capturing screenshots at regular intervals, tracking GPS location, and mirroring text messages to a secondary device. The complaint alleges that this software was installed without Graves's knowledge or consent, and that its installation constitutes a violation of the California Invasion of Privacy Act, specifically California Penal Code Section 632. 7 and Section 637-7, as well as potential violations of federal wiretapping statutes under 18 U.S.C. Section 2511. The fifth evidence category deals with what the complaint describes as retaliatory action and blacklisting following Graves's departure. According to the filing after leaving Sussex employment in May 2025, Graves applied for positions with 4 organizations in the entertainment and nonprofit sectors. The complaint alleges that in 3 of these 4 cases, Graves received initial positive responses and advanced to final round interviews, only to have the opportunities withdrawn without explanation within days of the organizations contacting Archewell for an employment reference. The complaint includes email correspondence from one hiring manager at an organization identified as the Global Philanthropy Initiative, who allegedly wrote to Graves on July 22, 2025, stating, and this is quoted from the complaint, "I am sorry, but we have received information about your previous employment that makes us unable to move forward, and I am not at liberty to share the specifics." The complaint alleges that this pattern constitutes tortious interference with prospective economic advantage and intentional infliction of emotional distress. The sixth category involves allegations of what the complaint terms a coordinated narrative suppression operation. According to the filing, Graves alleges that within days of retaining legal counsel and sending a pre-litigation demand letter to the Sussexes on October 15, 2025, she became aware of social media accounts posting false information about her personal life, including fabricated claims about substance abuse and mental health crises. The complaint identifies by URL 14 specific social media posts across Twitter, Instagram, and Reddit that it alleges were created by accounts with no prior posting history and that appeared within a 48-hour window between October 18th and October 20th, 2025. The complaint alleges that metadata analysis conducted by the plaintiff's digital forensic experts indicates that 6 of these 14 accounts were created using IP addresses that geolocate to Montecito, California. The seventh and final evidence category addresses the emotional and physical health consequences that Graves alleges resulted from her employment and its aftermath. The complaint includes records from two treating physicians and a licensed clinical psychologist who diagnosed Graves with post-traumatic stress disorder, generalized anxiety disorder, and major depressive episode, all allegedly onset during or immediately following her employment. Medical records referenced in the complaint document a 17-pound weight loss between March and December 2024, treatment for chronic insomnia beginning June 2024, and two emergency room visits at Cedars-Sinai Medical Center for what were described as acute anxiety episodes, one on August 3, 2024, and one on November 19, 2024. The total medical expenses documented in the complaint amount to $67,400, and the complaint seeks additional damages for projected future treatment costs, estimated at $140,000 over 10 years. But here is where this becomes truly significant beyond the individual allegations. When we reconstruct the timeline of Charlotte Graves's employment and its aftermath, a pattern emerges that transforms individual incidents into what appears to be a systematic operation. March 11, 2024, Graves signs employment contract, including comprehensive non-disclosure agreement running 23 pages. March 18, 2024, Graves begins work at the Montecito residence. April 2, 2024, first documented incident of verbal abuse, 15 days into employment. May through June 2024, verbal abuse incidents occur at an average frequency of 3.4 times per week, according to the complaints catalog. June 14, 2024, the charity call incident described earlier, resulting in the loss of a $350,000 partnership. July 2024, Graves begins maintaining a personal log of incidents on a device not issued by her employer. August 3, 2024, first emergency room visit at Cedars-Sinai. September 2024, Graves discovers surveillance software on her work phone. September 12, 2024, Graves retains a private forensic technology firm to examine the device. October through December 2024, the complaint alleges that expense reimbursement requests involving Archewell funds for personal purchases intensify, with $167,000 of the total, $412,600 occurring in this 3-month window alone. November 19, 2024, second emergency room visit. January 2025, Graves begins confidential consultation with Kaplan Marino LLP. February 2025, Graves begins systematically preserving evidence, including downloading her own email correspondence to a personal device. March 2025, Graves alleges she is excluded from key meetings and stripped of responsibilities in what she characterizes as constructive termination pressure. April 28, 2025, Graves submits letter of resignation. May 1, 2025, Graves receives threatening call from individual claiming to represent Schilling's partners. May 3, 2025, anonymous threatening note found under apartment door. May 4, 2025, LAPD report filed. May through July 2025, 3 employment opportunities allegedly torpedoed by negative references from Archewell. October 15, 2025, pre-litigation demand letter sent to Sussex legal team. October 18 through 20, 2025, coordinated social media smear campaign allegedly launched from Montecito IP addresses. October through December 2025, settlement negotiations fail. January 2026, final preparation of formal complaint. February 19, 2026, lawsuit filed in Los Angeles Superior Court. Notice the progression here. This is not random. This is not a series of unfortunate misunderstandings. What this timeline reveals, if the allegations are proven, is a cycle that begins with recruitment, escalates to abuse, monitors for loyalty, retaliates against departure, and then deploys legal, social, and professional weapons to ensure permanent silence. And the complaint alleges that Charlotte Graves is not the first person to experience this cycle, but merely the first person willing to file a lawsuit about it. Now let us examine what all of this means in concrete legal terms, because the consequences flowing from this complaint, if it proceeds, are substantial and potentially devastating. The $25 million damages figure breaks down as follows in the complaint: $5 million in compensatory damages for emotional distress, physical health consequences, and lost wages, $5 million in special damages for medical expenses both incurred and projected, career damage and relocation costs, and $15 million in punitive damages, which under California law require a showing of malice, oppression, or fraud by clear and convincing evidence under Civil Code Section 3294, but the financial exposure may be the least of the Sussex's concerns. The allegations regarding surveillance software, if proven, constitute criminal violations under California Penal Code Section 632. 7, which carries penalties of up to 1 year in county jail and fines up to $2,500 per violation, and Section 637-7, which addresses unauthorized tracking, federal wiretapping charges under 18 U.S.C. Section 2511 carry penalties of up to 5 years in federal prison. The allegations regarding misuse of Archewell Foundation funds open an entirely separate legal front. Charitable organizations in California are regulated by the Attorney General's office, and the allegations described in this complaint, if substantiated through discovery, would almost certainly trigger an investigation by the California Attorney General's Charitable Trust Section. Under California Government Code Section 12598, the Attorney General has broad authority to investigate and bring civil actions against charitable organizations engaged in self-dealing or diversion of charitable assets. Federal tax implications are equally severe. If Archewell Foundation funds were used for personal expenses as alleged, this could constitute private inurement in violation of Section 501c3 of the Internal Revenue Code, which could result in revocation of the foundation's tax-exempt status and substantial excise taxes under Section 4958. The IRS Criminal Investigation Division investigates cases where the amount of diverted funds exceeds $100,000, which the alleged $412,600 in misused funds clearly surpasses. Furthermore, the defamation counterclaims that will inevitably arise from the social media smear campaign allegations introduce additional legal complexity. If the plaintiff can demonstrate that fabricated social media accounts were created or directed by the defendants, this constitutes defamation per se under California law, carrying presumed damages without requiring proof of specific financial loss. So where does this go from here? Let us analyze the most likely scenarios based on the evidence, the legal landscape, the Sussex's historical behavior patterns, and the resources available to all parties. Scenario 1, aggressive early settlement. In this scenario, the Sussex legal team moves quickly to settle the case before discovery begins, offering Graves a substantial financial package in exchange for a comprehensive settlement agreement with strict confidentiality provisions. This approach has the advantage of preventing the discovery process from unearthing additional documents, emails, and financial records that could prove more damaging than what is already alleged. The settlement would likely need to be in the range of $3 to $5 million to satisfy both Graves and her attorneys, given the strength of the documented evidence. However, this scenario requires the Sussexes to have liquid assets or access to funds sufficient for such a payment, and recent reporting by Forbes has valued their total net worth at approximately $14 million, with significant illiquidity in their Montecito property, raising questions about whether a rapid large settlement is even financially feasible. Scenario 2, aggressive legal defense with counterattack. This scenario more closely aligns with the Sussexes' established pattern of responding to criticism. In this pathway, the defense files a motion to dismiss under California Code of Civil Procedure Section 425. 16. The anti-SLAPP statute, arguing that the complaint targets conduct in furtherance of free speech rights. Simultaneously, the defense files a cross-complaint against Graves alleging breach of the non-disclosure agreement, theft of confidential information through her preservation of emails, and intentional infliction of emotional distress through filing a meritless lawsuit designed to extract a settlement. This approach has significant risks. The anti-SLAPP motion is unlikely to succeed because employment disputes generally do not implicate the speech-related conduct the statute was designed to protect. The cross-complaint regarding the non-disclosure agreement could actually backfire because California courts have consistently held that non-disclosure agreements cannot be used to suppress evidence of illegal activity, and the allegations of surveillance, threats, and charity fraud would likely qualify as illegal conduct that cannot be contractually silenced. Scenario 3, protracted litigation with discovery warfare. In this scenario, neither side settles and the case proceeds through the discovery phase, which under California's Civil Discovery Act would entitle the plaintiff's attorneys to demand production of all Archewell financial records, all communications between the defendants and their staff, all communications with Schilling's partners regarding former employees, forensic images of all devices used by the defendants during the relevant period, and deposition testimony from both defendants and all former employees identified in the complaint. This scenario is catastrophic for the Sussexes regardless of the ultimate trial outcome because the discovery process itself would generate a continuous stream of revelations, documents, and sworn testimony over a period of 12 to 18 months. Each deposition transcript becomes public record. Each produced document becomes available to every journalist, commentator, and investigator who requests it. The information asymmetry that the Sussexes have maintained through non-disclosure agreements collapses entirely once a court orders production under penalty of contempt. Scenario 4, parallel criminal investigation triggered by civil proceedings. This represents the most severe potential outcome. If the civil discovery process produces evidence substantiating the allegations of surveillance, threats, and charity fraud, the Los Angeles District Attorney's Office and potentially the FBI would face significant public pressure to open criminal investigations. The LAPD report regarding the threatening note already establishes a law enforcement record. The forensic evidence of surveillance software creates a clear basis for criminal wiretapping charges. The financial irregularities, if documented through Archewell's own records produced in discovery, provide the foundation for charity fraud prosecution. In this scenario, the civil case becomes a vehicle for criminal exposure, and no settlement of the civil matter can prevent criminal prosecution because Charlotte Graves is not the complaining party in a criminal case. The people of the state of California or the United States of America would be. Based on everything we have examined tonight, the pattern of behavior documented across 7 assistants in 5 years, the legal strategy the Sussexes have historically employed, and the financial constraints they currently face, Scenario 3 represents the most probable path, though it contains within it the seeds of Scenario 4. The Sussexes will resist settlement because settlement requires admission through payment. They will resist discovery because discovery exposes everything. But the court will order discovery because that is how the legal system functions. And once those documents flow, the story will no longer be Charlotte Graves versus Meghan Markle. It will be the state of California asking what happened to $412,600 that donors gave to help people in need. The 30-day window for the defendants to file their initial response to the complaint expires on March 21, 2026. That response will tell us everything about which scenario the Sussexes have chosen. Are they settling? Are they fighting? Or are they hoping this goes away? The clock is ticking, and every day that passes without resolution is a day closer to discovery. Now, I want to hear from you. Type settlement if you think the Sussexes will pay to make this disappear. Type fight if you think they will launch an aggressive legal defense. Type collapse if you think this lawsuit will trigger the unraveling of their entire California operation. And type criminal if you think this leads to criminal charges within 12 months. Your response tells the algorithm this content matters, and it tells me what you want to see investigated next. If you want to know what happens when that March 24 deadline arrives, when the Archewell financial records are subpoenaed, when the depositions begin and sworn testimony replaces carefully managed public statements, you need to subscribe and hit that notification bell right now because this story is developing daily and the next revelation could come at any moment because what we have covered tonight is the legal dimension of this crisis. The real question, the question that connects Charlotte Graves's allegations to a much larger pattern, is how many other former employees are watching this video right now and considering whether they too should call Kaplan Marino. And based on what our sources are telling us, the answer to that question will be the subject of our next investigation, and it is a number that should terrify everyone in that Montecito estate. I am George Will, and I will see you in the next investigation.